Hello, everyone. It's a pleasure now to see you here again, and thank you all for joining us. I think that we can start now our meeting, and our event is organized in the framework of International Network of Judicial Reformers by the Group of Independent Lawyers and Democracy Index Georgia, with support of USAID Rule of Law program. So today we will discuss very important issue about independent judicial governance in search of efficient solutions for transnational democracies. To ensure independence of the judiciary and to defend judges from influence by the government, European institutes developed recommendation, and among these recommendations are recommendations which encourage the judicial councils to be composed by majority of judges. This standard is believed to be the best guarantee of judicial independence to the long-standing democracies where justice system matured by time. But on the contrary, the implementation of the standard in Eastern Partnership countries, which only started democratic transformation, has not led the expected result, and hence corrupt and politically dependent judges were strengthened and formed the groups, so-called clans, that received full control over the judicial system. And in order to address this problem, experts from Bulgaria, Georgia, Romania, Armenia, Moldova, and Ukraine united their efforts and prepared recommendations to ensure accountable and independent judicial governance in transitional democracies. So today we will discuss these problems. The event will be led by Halia Chizik, judicial reform expert from Ukraine, who has been involved in this process and elaborating this recommendation from very beginning, and her contribution is major. She gathered today really brilliant speakers today, and I welcome them today. Discussion will continue 1 hour and 30 minutes. It will be translated and recorded, and after it will be placed on our web page, Democracy Index Georgia and Independent Lawyers. So I want to present representative of Democracy and Governance Office of USAID Caucasus, the Rule of Law Project Manager, Rusudan Tapatadze, and ask her to make the opening remarks. And after, Halia will lead the discussion. Please, Russo, the floor is yours.
Hello, everyone. I don't want to tire this audience with like formal greetings and opening remarks. Very happy to see some familiar faces, some familiar names on the screen. Very happy to greet you on behalf of USAID. I would like to especially greet the colleagues from Ukraine, Halia, and if there is anyone else from Ukraine, and start the opening by wishing you the victory, not peace, but victory in this brutal and unfair war with our common neighbor. Now back to the topic of our discussion. It is definitely hard to overstate the importance of independent, professional, transparent, and accountable courts for the development of any country's democracy and economy. The role of the judiciary in ensuring the protection of human rights and separation of powers between the governance branches is essential, of course. And in Georgia's context, independent and accountable, transparent, efficient judiciary is also on the way of our path to European integration. As many of you know, may know, judicial reform is one of the conditions that Georgia needs to meet to get the candidacy status, and it's been on the EU association agenda for several years already. And this is something, it's not just a formal requirement, but EU integration is something that Georgian people firmly support and demand, that numerous polls show. The US government has continuously supported reforms in the justice system here in Georgia. We have been assisting also civil society organizations in their efforts to monitor, research, critically assess and discuss developments on the court system, and also propose, of course, recommendations on potential ways out. Unfortunately, here we don't have a tradition of an independent court system that would serve a role of an independent, impartial arbiter. Unfortunately, our governments, all of them, since gaining independence, they couldn't resist this temptation of controlling the judiciary and considering it as a political tool. During the last decade, too, there have been carried out 4 waves of reforms that improved the legal framework in some way. However, you may have heard that judiciary is still very much criticized by internal and international partners for informal, clan-based government, corporatism, lack of transparency, and insufficient independence of judges. Unfortunately, the judicial reform process has been very much polarized too, and there is very little space now to discuss the reforms in a civil way. We are happy to support the group of independent lawyers and Democracy Index Georgia. Both groups have an important contribution in the discourse of the judiciary system reform in Georgia. Of course, we know that the problems like lack of accountability of judiciary, judicial corporatism, concentration of excessive powers in the hands of the judicial councils, etc., exist in many countries. They are not unique to Georgia. And those solutions that are being discussed now as potential ways out here are already being tested in other places. And this is why I'm very happy that USAID has a chance to support international network of judicial reformers. These discussions that network hosts have already become an important platform for us to learn about trending developments in the justice systems and judiciaries elsewhere in Europe regions, etc. I'm looking forward to the discussion today, and I won't take more of your time, and we'll leave the floor to our distinguished experts. Thank you, Keta, Eka, the independent lawyers and Democracy Index for your work in organizing this and other discussions under the INJI umbrella. Thank you.
Thank you so much, Russo. I will ask Halia to lead our discussion. Halia, the floor is yours, and we can start.
Good afternoon, colleagues. Thank you, Keta. Thank you for your kind words at the beginning of our event. And dear Sudan, thank you for reminding that there is still war going on in Ukraine, and victory is all we pray and aspire for. I'm really grateful and honored to be here today. I believe that the topic of our discussion is extremely important. Actually, it's not the first time we meet on the platform of network of judicial reformers to discuss these recommendations and initiative to promote new standards across European countries. And in fact, our today's discussion is part of our continuous efforts aimed at introducing alternative working solutions for countries trying to establish independent judiciaries. So during the next hour, we will be actually discussing efficient solutions that can help build and sustain independent and accountable judiciaries. So before I move to the brief presentation of the recommendations, I'd like to present you our distinguished speakers today. I'm sorry, there are some
yes, maybe
noise,
some,
so please,
please,
yeah.
yes, there are microphones, and please turn off microphones, and it will be okay. Thank you.
Okay, so we are honored today with the presence of the following speakers. We have Ms. Lavly Perling with us. She formerly served as Prosecutor General in Estonia, and she is involved now in Moldova and Ukraine. In Ukraine, Ms. Perling is a member of Ethics Council, a special body established to conduct integrity checks of the candidates who apply for High Council of Justice. And Lavly was also invited to be a member of the vetting commission in Moldova. So it will be very valuable for us to hear about Ms. Perling's experience. We also have today Dr. Tilman Hoppe, who, in my humble opinion, has the richest experience when it comes to judicial reforms in transitional democracies, when it comes to judicial vetting and checks. He has also his personal experience being a member of the panel that selected the head of anti-corruption agency in Ukraine. So I also hope that Tilman will share his thoughts, reflections, and ideas on the issue. We also have outstanding expert from Georgia. This is Ms. Nona Tsutoria, who has different experiences. She previously served as a judge in European Court of Human Rights. She has experience being involved in Ukraine. She was a member of the panel that selected the head of anti-corruption prosecutor in Ukraine, and now she is involved in Moldova, being a member of so-called pre-vetting commission, selecting members of judicial and prosecutorial councils. And last but not the least, we have Mr. Taras Pashuk, who is legal advisor from the Secretary of the Venice Commission, whose inputs and insights are very valuable for us today. So before we move to the discussion with our invited experts, which in my opinion is the most important and fruitful part of our today's event. I'd like to warm you all up by presenting the recommendations, the document with which this all started. So basically, a few years ago, I remember that it was some event organized by colleagues from Georgia, by a group of independent lawyers, and I was invited to speak about judicial reform in Ukraine. And at that time, it did strike me that, in fact, Ukraine, with its problems with judicial clans, usurping powers in judicial councils, is not unique, because Georgia is facing the same problems. And then when I looked at Moldova, the situation was the same. And then we asked experts from Armenia, and it turned out that they have basically the same problems. All countries implemented this European standards that suggests that in order to ensure judicial independence, countries should establish judicial councils and secure that at least half or even majority of its members should be judges elected by their peers. And it is believed that it is like the most important, the most essential thing that has to be done if you want to have independent judiciary. So we did that, but this didn't help us to actually to ensure the judiciary is independent. Judges just cover up for judges keep taking bribes, and the quality of judiciary and of justice has not changed. So, like, what the problem? Maybe we did something wrong with the implementation. Maybe our legislation does not meet European standards. And when we started looking at and searching for answers, we realized that our laws are not bad. And well, Venice Commission assessing our laws at that time said that they are fine. And in establishing Judicial Council this way, you are meeting all the important requirements. So laws were not bad. The implementation of this new legislation sometimes was bad, but still, why we still do not have independent judiciaries? And we came to a joint conclusion that independent from political influence judicial councils, where judges decide on everything, are not a solution for countries where judges themselves are not independent. Because what actually happened in Georgia, Moldova, and Ukraine is that corrupt, dependent judges with poor ethics just got more powers. They got powers to defend themselves from any kind of checks and scrutiny. They just started using these best European standards as a shield against any reasonable attempts aimed at ensuring their integrity. So we started looking for and trying some other solutions how to ensure that our judiciary is independent and honest at the same time. And this is how we came up with the recommendation. And now I'll share my screen for a moment to briefly guide you through the document. So what we are talking about today are the recommendations toward ensuring accountable and independent judicial governance. Like I'm holding this document here, like we have a printed version. It was prepared and presented in 2021. And basically, these are the result of the efforts of the experts from different organizations from 6 countries. When we were working on the document, we were also advised by Dr. Tilman Hoppe, who has joined us today, and expert from Czech Republic, David Kosar. So there are actually only 8 ideas in this document, and here are these ideas. First of all, integrity and accountability are as important as independence when it comes to judicial governance. And of course, powers judges receive have to be counterbalanced with their duties. So in our focus, not only independence should be placed, but also integrity and accountability. Second idea, second recommendation, is that local context matters. Because why this main idea that judges governing themselves is as the most important guarantee for judicial independence has not worked in transitional democracies like Georgia, Moldova, and Ukraine, is because this principle, this recommendation is based on the experience of Western democracies that matured over years, like over centuries. They were working on establishing, building independent judiciaries. And when those countries finally got to the point when their judiciary is independent, they were like, okay, let's find solutions how to defend judges from undue influences, in particular political influences. And of course, if our goal is to defend judges from politicians, then we let judges govern themselves. But it's not working the same way when judges are not independent. And this is why we believe it's important to take into consideration local context, history, culture, and relationships between judges and society. Of course, we agree that judges should be governed by independent authority that has to be free both from politicians, governments, oligarchs, and also from influential judges and group of interest within judiciary. So by this, we're simply trying to say that it's important to ensure that judges are independent, not only from legislative or executive branches of power, but also from improper influences within judicial system, because it's and this idea comes, of course, from our own experience. Next idea that we believe that the authority that is governing judges should be composed of independent, honest professionals. So our main focus here is not that there should be judges or there should be attorneys or prosecutors. It not matters so much, but what really matters, what should be the first priority here is that those people who are in charge of selection and disciplining of judges are independent and decent professionals. So where do we get those professionals? Our solution to that is open, public, and fair selection procedure. And this is one of the most important recommendations coming from experience of Ukraine, Moldova, and some other countries who tried that, is that there should be independent professionals involved in selection of members of judicial councils who have impeccable reputation and trust of society. But the most important that, well, it can't be political institution, governmental institutions. This should be decent, honest professionals who decide on those people who will be later deciding on the judicial career. And moving forward, at least from the experience of Ukraine and Moldova, this can be, and I believe this should be, and we can discuss that later with you, dear experts. This should be experts representing civil society organizations and experts, international experts as well. But again, let's not forget about taking into consideration local culture, context, and other stuff. But this is a solution. And the last two recommendations are about how to discipline and monitor the activities of those people who are elected to judicial councils. Of course, they should follow general anti-corruption requirements and measures envisioned by national systems. And furthermore, they should even comply with higher standards. This idea also comes from at least the experience of Ukraine, because from time to time there are attempts to say that judges should not be up to some integrity checks. And if we have time later, I can give you examples when why it's bad when judges are trying to avoid scrutinies, but I don't want to take time and want for us all to listen what experts have to say. It's just I just want to emphasize on the importance that judges follow sometimes maybe even higher integrity standards, because they have huge powers. and huge responsibilities. And of course, when they misconduct, there should be effective measures and procedures in place to bring those members to responsibility. So these are the recommendations, and importantly, we do not suggest any strict models, strict rules that have to be followed. These are the only some very general recommendations what can be done, and I would even say that these recommendations is not a suggested model. For me, it's rather a way to look at, a way to move forward with, trying to make judiciary accountable, independent. Different options and solutions are possible. Different architecture of judicial councils is possible. So basically, when we worked on the recommendations, we all agreed that it is important to have independent council in charge of disciplining and appointing of judges, as European recommendations and European standards suggest. The difference we make is that we question the need to ensure that only judges or the majority of judges should be in charge of that body, and that they have to be elected by judges. So our goal when we worked on that recommendations was to introduce alternative solutions and to incorporate and reflect on lessons learned from different countries, and to share successful solutions in different countries. And now, as I've said, we are moving to the most important part of our discussion, when our experts can share their thoughts and ideas. And before I give the floor to the experts, I just have to remind you that to be brief. It's my only expectation from you to try to be brief, and we have from 7 to 10 minutes for each speaker. So please follow the time, because we promised to everyone that our event will end at 16:30 set. So yeah, like this is my only expectation from you, and please be bold, be open when sharing with us. So my first question is to Tilman. As I've said, in my opinion, you have the richest experience. You've been involved in different countries, advising governments on judicial reforms, in particular vetting of judges. So and you worked with us on the recommendations. So my question to you is, do you agree with the idea that Ukraine, Moldova, Georgia, maybe some other countries in the region are now having just extraordinary problems that require some ad hoc solutions, but at the same time, this idea that judges should govern themselves remains a universal standard? Or do you think that there should be alternatives to the model when judges govern themselves, and there is a room for different models? So do you think that the only way to secure and ensure independence of judiciary is to make sure that judges govern themselves, or there are other possibilities? And yeah, please.
Thank you very much. You wanted a short statement, so I will just say I agree, except for that I don't think I have the richest experience around here. I'm very curious to hear the other people around the table. They have experiences I don't have. But of course, you wanted to hear a little bit more than just a yes from me. Well, I think what we're witnessing right now with the vetting since a couple of years, which started prominently in Albania is a revolution. It's a change in the concept that judges are untouchable and that we need to fight corruption in the judiciary the same way we are fighting it in Sweden, or in Denmark, or in Germany, or UK. And the revolution that took part, we realized we cannot fight corruption in Ukraine or in Moldova or Kosovo the same way as as we're doing in Western European countries. And I think it was also a learning process for the experts involved. Also, I would suggest it was a learning process for all of us, myself included, but also for members of the Venice Commission. If we look at the opinions of the Venice Commission and compare them from 10 years ago until today, we can see there has been a huge development, and I commend the Venice Commission for its strong support it gave repeatedly to the vetting as a tool. Also, the European Court of Human Rights. To me, the first Albania judgment in 2021, I mean, I almost went down on my knees when I read the judgment. I was a little bit burned from, how shall I say, as an anti-corruption activist. I was always hearing this cliche of independence of judiciary and human rights and blah, blah, blah. And so whenever there was an efficient tool in fighting corruption in the judiciary, there were some obstacles, so to speak, in terms of human rights and old constitutional concepts. So I'm very grateful for this revolution on the level of the European Court of Human Rights, on the level of the Venice Commission. And the relevance in practice is very obvious and very urgent. When we look, for example, at the results of the Pre-Vetting Commission, where Nonna was a member, and she knows much more than me about it, but I supported a little bit in the background on the financial aspects of unexplained wealth. The rate of candidates being disvetted was far above 50%. So candidates knew they would be vetted, and they still had the brazenness and the boldness to still apply and think they would get through the process and become appointed. So this for me expresses decades of an experience where they were untouched and where they could reign freely and live out their corruption freely. And I think for them, it's also a learning process. Them, I mean the rotten side of the judiciary, as opposed to the many colleagues whom we don't speak about today, which are the ones with integrity, who have to live in such a shameful environment. It's a learning process now for the corrupt judges across many countries that the golden years are over, the golden years of corruption in a certain way. Of course, not for all countries. In Armenia, we don't have international vetting. In Georgia, the discussion is still going on. I think Anthony Hooper was also working on some reforms earlier. In Kosovo, the discussion is endless about introducing the tool. As you were saying, it's all about the word independence and what it means. And to me, if there's still corruption and not accountability, the judiciary cannot even start to be independent. So the word independent has been abused a lot over the last decades, as you rightly mentioned, and we are now in the middle of this revolution, and I'm very grateful for it and happy to contribute further to it.
A follow-up question to you. Do you think that with these recommendations we are moving in right direction, and maybe reflecting on the experience of Ukraine, Moldova, some other countries? Is there something essential we are missing right now? Is there something we should add to the document to make it like in fuller way incorporating different experiences and the problems?
Yeah, thank you. Certainly it's going into the right direction. And a high-ranking European Union official once told me in confidence, so I'm not going to say his name, he said in the early 90s and in the early 2000s, we were actually creating horrible monsters. Our dogma was to create this judicial councils all over the accession states and the neighbor states. And after a couple of years, we realized we just gave them a carte blanche for even more corruption, to put it a little bit black and white. And of course, the intention was right to kind of like give the judiciary like a distance to politics. And this not only happened in Europe, the same thing happened, by the way, also in South America, when they started this judicial councils and realized after a couple of years, they kind of like created the opposite of what they intended. So your recommendations are very important in this regard. Of course, they are they are quite general still. The question is, what does it look like concretely? What do asset declarations look like in real life? What does disciplinary accountability look like in real life? Do you have an anti-corruption court? I think in Ukraine, that was a game changer. All of these things we have, including pre-vetting or all these bribery investigations, I think we would not have them hadn't it been for the Hague. So I think there's a lot of things underneath these recommendations, which are actually very important and which make the real difference. You can see it, by the way, also in the vetting commissions. We see some kind of like development over the years in how the vetting commissions work and an increased level of forensic accounting. So the very first vetting commission, the PCIe, I think it was working excellently and had an excellent reputation, but they were working quite roughly in terms of forensic accounting. You didn't declare a car, you didn't declare an apartment. Okay, it is vetted. And if I go to the other end of the spectrum, the pre-vetting commission in Moldova, they were doing forensic accounting on a very detailed level. And that, again, made a difference, I believe, in the high ratio of candidates disvetted, because you see so much more if you follow a detailed, narrow, fine net forensic accounting methodology for detecting unexplained wealth. So let's say if the recommendations are above here, there's a lot of details to put them in practice. And those details actually are the game changers. So in that sense, I'm sure in the next years, experts and organizations and NGOs and academics will draw conclusions and maybe the Venice Commission will do more work on what vetting might look like or judicial accountability might look like. And that will inform reforms in other countries then in more detail and on a more solid base.
That's actually brilliant thoughts. And I'd like to our representative of the Venice Commission to reflect on these ideas later. But now I'd like to pass the floor to Lovely. Lovely, I have very specific questions to you. So as I've said, Lovely is an acting member of the Ethics Council, a special body established in Ukraine to conduct integrity scrutiny of the candidates who apply for the High Council of Justice, which is the highest judicial institution in Ukraine. And now Lovely is also involved in vetting of judges in Moldova. Ukraine made very bold move by not only inviting international experts to this panel as selecting candidates for the High Council of Justice, but also by granting those international experts prevailing vote in the process. But at the same time, Ukraine followed European recommendations by ensuring that half of members of this panel are Ukrainian judges nominated by Council of Judges. So my question to you, Lovely, is how was it to cooperate with Ukrainian judges who were representing the system that has to be reformed? Did you manage to establish effective cooperation? Was it easy? Like, did you move together in the same direction? And did Ukrainian judges agreed with internationals when it came to discussing candidates and deciding who should be promoted and who should be banned from the competition? And I guess the trickiest question here is, do you think that Ukrainian judges would act the same way without internationals involved? Would the outcomes of the process be the same without internationals' involvement? And one more question here. I hope that I'm not overwhelming you with my questions. I wasn't planning to ask you about that, but since you mentioned your Estonian experience, I just had this assumption that Estonia didn't have the same problems with judicial governance as we do, because maybe you did your homework after the collapse of Soviet Union. But at the same time, you've said that what we have in common is that we inherited Soviet system, including judicial system, when judges have very bad understanding of ethics and independence. So maybe there is something in experience of Estonia that can be helpful for Ukraine, Georgia, and Moldova, and something that we can add to the recommendation. Now I'm finishing, and the floor is yours.
Thank you. So many questions. And I would like to start in the same way as Tilman Hoppe, that your first question was how it was cooperate with Ukrainian judges. Was it difficult or not so difficult? Was the good cooperation? And I would like to answer, yes, it was quite good cooperation, and that's all. But you know, my second point before I answer directly to your questions is that I have a little bit different opinion than Tilman. If he mentioned very well that it's different how to fight against corruption in West or in East part of Europe. And you know, I have a strategy of three legs stools. Remember it. And I believe that the first stool, where is the key of a successful country? And you know, all the taburets on stools, they have 3 legs, and they must be equal, because if they are not equal, the stool is not stable. Receipt of a successful country, in my opinion, is, and also this is the answer to your last question about the Estonian experience. The first, strong economy. The second, really established rule of law. And the third, young generation. It's simple. It's so simple. This is one of my principles. Keep simple, keep things simple. And it usually works. Because if you don't understand why we fight against corruption, judges take bribery, someone gives bribery, everybody is happy. What's the point of a fight of corruption? If you start to talk about future, about the next generation, about the economy, it depends how strong is state. Corruption makes states weak. This is the first stool. The second stool, and the first stool, I think this is where our answer to the question, why to be against corruption? My second stool, it talk about lifestyle crimes, corruption, taxes, fraud, and organized crime, and we can continue. And my point is that, you know, cultures and countries and people can be different. But the answer to the question, why and how, are quite similar. The first tool is the same everywhere, strong economy, rule of law, and young generation. The second tool, how to fight against the lifestyle crimes. And corruption is lifestyle crimes. This is not question of, or corruption is not legal term. you know, in my opinion, this is question of mentality, this is question of economy. And again, we can talk about 3 legs. What do we need that to be successful in the fight? The first, we need political will. We need it. No, don't think about independency. Independence is feeling by charges, feeling by parts, feeling by the people. But we need political will. The second, we need efficient law. And the third, we need motivated fighters. And I say everywhere, it's easy to fight against corruption if we will have the 3 things everywhere. And now the third, where I agree with Tilman Hoppe. Countries are different and we need different tools in different countries. And this is the third stool. This is question about the roadmap. And now I start to answer to your question. I think everywhere are the same 3 legs. The first is people. The answer, was it difficult or not difficult to cooperate? It depends. Did we argue? Yes, of course. Did we argue seriously? Yes, of course. But I hope we will talk about challenges. But one of my principles is that only people who are not corrupted can fight against corruption. It's clear. It's everywhere clear. And you must find the people who declare and who share the values that we must be fight against, we must be against corruption. No, if I tell you the first leg is people, and people are everywhere, people, believe me. I have seen already in Moldova, people are people, and I have seen everywhere the people who really want to fight against corruption. And there were differences in very different places. I think I believe the most important declaration in the very beginning, and if I could success something, then please make agreements and declare who you are and what do you do, what is point of your work, because we are lawyers here. We can talk about hours, about court decisions, about the law, about the norms. Sorry, by the end of the day, it doesn't matter. What does it matter? This is question of values. And we declared very clearly in Ukraine, we don't do compromises if we talk about integrity. Yes, there were a lot of critical questions, but still the candidates or the selected persons are not good enough. But I say, sorry, I can confirm that the process was fully transparent. We worked only with material information, but we did the best and we didn't do the compromises. And it's not possible to do compromises. It wasn't never a question, even in very difficult situation, when we thought that maybe the competition, I don't know, can fail. Still, we decided no compromises. And I think it worked. So the people, the second is priorities, because one of the challenges everywhere is quality of information and quantity of information. And you must think about through the priorities and you must focus. What does it mean in a very practical way? Use always the plans, use always the schedules, and again, agreements and values. And people must feel that if I talk about values, and this is not some kind of theoretical topic, no, this is tool in our team. And if you ask from me, to what kind of processes need the international expert, then I would like to say yes. But for international experts, I would like to tell that at least I have thought it, but I never take the tone or don't choose the attitude that I am the international expert. No, because my principle is that I am guest, I am just a supporter, and only people of this country can build up the state. So people, priorities, and PPP, publishing or communication. I think this is one of the challenges, because in one day meet strangers, different systems, different understanding, where is adversarial proceeding in USA and in UK, and I am from Estonia, from Soviet Union experiences. And it's really important, the fourth bridge, always remember, build the bridges between the people, between the bodies, between a different group in society, and believe it works. So I finish here, and I can confirm, if your final question was, what about the results of Ethics Council? Could it be the same with or without international? Then my honest answer is, I think it was different, but only because that I think we all the time thought about our motivation and point why we are here. And my final story is from the very beginning, and I promise this is my final story. Before I started to work in Ethics Council, I even didn't know what does it mean. Because I had been prosecutor in Estonia, and I had worked in Ukraine, yes, already 2 years before I started as member of Ethics Council. And I remember when one EU official told me that, lovely, we need international experts. And I asked why. And he answered to me, because you are independent, you are free. And there are no connection in judiciary and for you, because you don't know any charges in Ukraine or now in Moldova. You can only think about through the perspective of integrity. And the second point, there are no influenced by oligarch or by politician. Here we are. And I think the most important is to think that there will be always balance. Who are the international experts in the bodies? Because we need both. We need theory and we need practice. We need practitioners, and we need the people who know what does it mean, the fight against corruption. Because for practitioners, this is like journey to history. If you said that we didn't have in Estonia the same problem. Yes, we had 38 policemen who took bribery. All the people in police took the bribery. 3 judges during 1 year who took the bribery. But we didn't compromise. That's all from my side. Sorry, maybe it wasn't answered.
It is, and thank you very much. I hesitated to interrupt here because it was interesting to follow the flight of your thoughts. But we have to be time-wise, and now I'm giving the floor to Nona Tsatsouria. Nona, you also have very rich experience. Not only as a judge of European Court of Human Rights, though I believe that you have a lot of stories to share from that experience, but your recent experience being a member of, being an international expert in a panel in Ukraine, selecting leader for anti-corruption prosecutor's office, and now you have experience from Moldova, selecting members of judicial and prosecutorial councils. So basically my question to you is the same that I asked Lovely. Do you agree with the statement that it was important to have outside experts involved, and what are advantages and maybe disadvantages you see in the involvement of outside experts, of internationals, and do you actually agree? Do you believe that internationals' involvement helps to get better results and outcomes of the process? So please, the floor is yours.
Greetings to everyone. Thank you for your question. Indeed, I was a part of the SAPO Selection Commission, and also I'm now a member of the Special Commission, Preventing Commission in Moldova. And to answer your question shortly, I absolutely believe in international composition of the commissions, and I think that this is crucial. I think this is the guarantee that those procedures and those processes will be successful. I'm a strong believer of this. In Ukraine, in SAPO, we had different composition. We had 7 members elected by the parliament, 4 appointed by the prosecutors, and out of 4, only 3 were internationals. But still, I think our participation was absolute. At the moment, only 2 of those cases are resolved by the Supreme Court, and the court upheld our decisions, and other 25 appeals are pending. So as to more additional, as to other statistics, out of 67 candidates, 24 were women and 43 men. And so far, the commission completed the evaluation of 59 candidates, and only 16 candidates passed the evaluation and 43 candidates failed. So I would also like to share with you some general observations concerning the commission. We don't need statistics. I can continue without that. First of all, the pace of the work of the commission has been slower than what in particular Moldovan authorities had expected. It was hoped that by the end of 2022, a new composition of the Superior Council of Magistracy would be operational, but it became almost immediately obvious to the commission that the deadline set by the law was very unrealistic. So according to the original version of the law, the commission was to cease its work by the end of 2022, but it appeared unrealistic. The commission's mandate was extended till the end of June, and eventually it was extended until the completion of the examination by the Supreme Court of Justice of the last appeal filed against the decision of the Evaluation Commission. Throughout the process, the Commission fully recognized the political desire for rapid results in the process of legal reform. At the same time, Commission considered that the quality of the evaluation process and decisions was more important than political or public expectation to speed up the process. The guiding principle for the Commission always remained quality over speed, and we were always pleased to know that the European Union was supportive of this approach. The fact that the Commission received information from dozens of institutions also meant that the substantial time was required to analyze the vast amount of information, particularly in view of complexities of many candidates. Furthermore, the Commission faced staffing challenges throughout its mandate, and therefore Commission members had to compensate for the inability to fill essential positions. Last but not least, the Commission members were and are grateful to have had the privilege to participate in this very important effort. And as it was noted by Tilman, it has been a unique experience for our Commission members, for the staff, and we all were learning in the process. Certainly we hope that this knowledge will be passed through other commissions, especially Commission number 2, which is about, which actually started already its activities. And my last observation, and I think this is something we learned as a commission, is that it is very important to start the reform of the Supreme Court as soon as possible, at least in parallel with the pre-vetting, or it should precede actually pre-vetting. So pre-vetting of the Superior Council of Magistracy. I think this is my observation as a commission member. I don't know how far it is shared, but I think that we suffered a lot because of non-reformed Supreme Court in this process.
Thank you.
This is all what I wanted to say, and I'm happy to answer any other questions.
Yes, thank you very much. Everything is clear, and I have a follow-up question to you, and I hope that you'll be able to answer it very, very briefly. So, interestingly, the composition of this panel in Moldova is different from what was in case of Essex Council, where we have 3 internationals and 3 Ukrainian judges. In Moldova, there are 3 internationals and 3 experts nominated by the parliament, but they are not all judges.
No.
So do you think that it's crucially important to have judges represented in panels selecting and evaluating judicial governance, and should the number of judges be equal to non-judicial members, or it's not as important as the quality of the members itself?
I don't consider that this is important. We have 1 former judge, but none of the members are acting judges. So I personally don't think that this is determined. It should be determined. No, I don't think so. I think that the quality of the members should prevail. Yeah.
Great, thank you very much, and especially thank you for being very brief. And now, finally, I want to give the floor to Mr. Taras Pashuk, who is a legal advisor in the Secretariat of the Venice Commission. It's not an accident that I'm addressing you the last one. I really want, if it's possible, for you to reflect on ideas and opinions expressed by our speakers. And my specific question to you is the following. I have to tell that Venice Commission has been truly and extremely supportive and understanding when it comes to assessing Ukraine's anti-corruption and rule of law reforms. And comparing to the opinions of the Venice Commission made in the past, to the opinions of the Venice Commission on Ukraine reforms, we have to agree. I believe we all agree that Venice Commission made very bold conclusions, which go far beyond its previous opinions and conclusion, because Venice Commission actually supported the idea that international experts should have prevailing vote in the process of assessing candidates for the High Council of Justice. But at the same time, we are afraid that Venice Commission might not follow the same approach when assessing the reforms introduced in other countries. And unfortunately, there is no political support to genuine reform of judiciary in Georgia, but I'm sure there will be the reform in the future. And this reform will be assessed by the Venice Commission. And the question is whether the Venice Commission will follow its conclusion expressed in opinions on Ukraine, in opinions on Moldova, when assessing Georgia and other countries' reforms, maybe Armenia's or other countries from the region. So the question is, and I'm sorry if I'm making it hard to enter these questions. The question is there is a way for us to unite our efforts to work jointly with the Venice Commission on to keep developing the recommendations, and maybe there is a way Venice Commission can address all these new solutions, not only in separate opinions, but in some kind of general document, as Tillman suggested, that maybe Venice Commission will be the one that will summarize all these different experiences and introduce these new solutions. So please, Taras, now the floor is yours. Feel free to share your ideas and opinions on that subject.
Thank you very much for inviting us to this important discussion. But before I start answering your question, I saw that Lovely wanted to intervene and to make some comment with regard to what Nona presented. So I would be glad to hear.
Sorry, I just again wanted to tell that I have seen both Ethics Council in Ukraine, where were judges on board, and now I see the Moldova. I of course don't take it like, I don't know, some kind of final consequences, but I feel that this is not practical question, but this is question of pride of judiciary in the country, and I believe that judges could participate. Why? Because I believe a self-cleanness also. Like I told you, international members are important, they can support, but in the long perspective, I would like to believe that, again, by the end of the day, this is not question of trust between the people and judiciary. That's the point. And if we don't trust even the one or two judges in this level, how the people of a country could trust the judiciary as whole? Just my personal opinion, and I saw that at least the judges in Ukraine, like I told, yes, we argued, but we cooperated, and we cooperated very well.
Yeah.
Thank you for this input. And now, Taras, please, the floor is yours.
Yes. This is a very important discussion, and it seems to me that we are talking, first remark, we are talking about different phenomena. So on the one side, we are speaking about judicial councils, which are designed to work in normal conditions of the society and functioning of the judiciary. On the other hand, we talked a lot about some extraordinary committees which aim to address the problem of exceptional vetting of judiciary, which is unheard in terms, if you're talking about the judicial independence and so on, because judges should be protected by the principle of judicial independence, and guarantees of tenure are important in this regard. Nevertheless, given the exceptional level of corruption and problems with integrity in the judiciary, certain countries decided to pursue this model, these different models of vetting, of extraordinary vetting of judges, because the level of trust of the judiciary by the society was exceptionally low. And all these examples that we heard today were carefully analyzed by the Venice Commission, and nothing moved forward before the Venice Commission provided their opinions on these extraordinary and exceptional models of vetting of the judiciary, of the particular part of the judiciary, for example, highest courts, and also the judicial councils themselves, like in Ukraine, like in Moldova. So I would like to distinguish these two different phenomena. What are the recommendations for the normal functioning of the judiciary and the model of judicial councils as a part of this normal functioning? And secondly, the extraordinary measures that have to be taken because of the critical level of trust by the judiciary. Now, when we are talking about these vetting procedures, the Venice Commission supported the idea of participation of international partners because of the difficult situation in the country and because of total mistrust by the society in these institutions. Because, well, international partners may provide more guarantees of independence and objective assessment of the integrity of the participants, of the candidates, or of the sitting judges or sitting members of the Judicial Council, and so on, depending on who is being assessed. There are two problems with these models. First is legal issue, because normally we will not find in the Constitution these grounds of extraordinary assessment of judges. If we do find, or we find a solution by way of changing the Constitution, by way of finding an interpretation which would be acceptable in terms of consistent application of rules, it could work. The second issue is political issues. This is what Lovely was talking about. If there is a political will, and of course we can find a solution. But if we don't have a political will, you can invent any legal channels how to proceed, but then it will not work out because there is simply no political will. And you will always, with good lawyers, you will always find a solution how to circumvent this legal channel. So any recommendations from international organizations, European organizations, will not be simply implemented correctly and genuinely if there is no political will. So we have to keep it in mind when we are talking about the recommendation, improving and changing the recommendation and so on. Now, as regards the ordinary situation when we have judicial councils and how they should function. And specifically with regards to the recommendations that Halia presented us today. Some of these recommendations are quite general, and they do not really contradict anything what the Council of Europe and the Venice Commission in particular has said. Like, for example, the question of relationship between judicial independence and duties, the first recommendation. Well, of course, we are talking about judicial independence, which is not the absolute idea. It is limited by judicial accountability. Because judge should be accountable, he or she cannot be simply independent, he should be accountable. So the question of judicial liability always goes hand in hand with judicial independence. And this is what we are talking about always when we are talking about the judicial independence, because the question of judicial disciplinary liability, the institutional basis for judicial liability, this is what we are talking about in Judicial Council, because Judicial Council, one of the functions of Judicial Council is to ensure the judge is responsible, the judge is held liable for his mistake, of his misconduct. And this is about all the institutional basis for the function of the judiciary. So the question of duties, the question of accountability always goes hand in hand. The Venice Commission has been talking about the grounds for legal liability of judge, and also about the procedures, how to ensure the proper and fair procedure for judge to be held liable, so that that any body which is responsible for holding a judge accountable does not abuse its powers in order to subordinate a judge. We were talking about the importance of judicial independence, but if disciplinary liability is used as a tool to influence a judge, is it good for the society? I don't think so. We all want to have judicial branch independent, but accountability should be exercised in a proper way. It should be strong, but it should not be abused by the body which is going to apply these instruments. So that is why the correct organization of the judicial councils, which normally have the powers of disciplinary influence on judges, is very important, because the judicial council can become a very serious instrument of influencing judges. Now, the idea of majority of judges in the judicial councils, where does it come from? If you look at the practice and the experience of, well, firstly, it is not the universal standard. It is the standard which has been developed in the European continent. But we can find similar ideas in other continents, also in the United States. The problem is not about giving exclusive rights for judges to decide, but to protect the judges. Because self-control, if we trust judiciary, well, if we don't trust them, then we should have international experts everywhere in the judiciary. But if we trust national judges, then we should trust that they can decide the questions of liability, integrity themselves. And the problem was historically, actually, that these judicial councils were controlled by the political power, by the executive. And that is where this principle of majority or half of the judges to be present in the judicial council arose, to protect the judiciary from improper influence by the executive on the judiciary. One issue. Second issue, why we have this principle, is that judicial council has very specific and specialist functions. I'm not sure that even our experience in previous years where non-professionals were trying to decide specific questions was a successful experience. In Soviet Union, in the beginning of Soviet Union, we had these examples when after the revolution of 1917, everybody was allowed to decide to take political decisions everywhere in the government. So we know the results. So if we are talking about serious and specialist and very specific questions, this should be left to the professionals. And here we are talking about the legal responsibility and a very specific subject. It is judge who has to be brought to responsibility for his mistakes, for his misconduct, and so on. So professional control over judiciary is another reason why there should be judges present in the judicial councils. But this principle should not be exaggerated. This is what we have had in Georgia when so-called lay members were not simply appointed to the Judicial Council. The recent opinions of the Venice Commission suggested that, well, there should be a substantive part of judges in the judicial councils. However, substantive participation of judges elected by their peers does not mean that there should be 100% of judges in the judicial council. So who should be these other members? This is the concept of lay members, and these lay members should be the representatives of other legal professions who would be also providing the guarantee of avoiding the risk of judicial corporatism, and also ensure the external view and connection, better connection with civil society. There are different models how to ensure the participation of lay members in the judicial councils.
I'm sorry to interrupt you. We are running out of time, and I have to tell that I cannot agree with you more. Trust is essential, and actually when there is no trust, this is when we involve outside experts, and I'm really sorry we do not have enough time, because we focus a lot on international involvement, but I believe a successful solution is to have civil society experts involved in the process too, and I hope maybe we'll have a chance to discuss it during our next event. Taras, my last question to you, again, I hope you'll be very brief, would be very practical one. Do you think there is a possibility that Venice Commission can come up with some kind of general recommendations, elaborating these different models tried in Ukraine, in Moldova, in Albania, suggesting options for how to achieve independent judiciaries, for example, as Stillman has said? What works for Moldova is that they've got a lot of information, and they got deep in the details assessing financial status of the candidates, and it worked. In Ukraine, we had anti-corruption court, and it seems successful. So do you think that Venice Commission can prepare a document systemizing all the different solutions that worked in different countries, and introduce them as possible models, possible solutions for countries seeking for that solutions?
I think we already have these documents. We have the compilation of Venice Commission opinions with regard to judiciary, and we have report on judicial independence. So if you visit the website of the Venice Commission, you will be able to see the relevant compilations, and this should not be, and currently there is the update of the report on judicial independence is being under preparation, so it will be available.
Great. It's nice to hear that you are working on the document right now. Maybe there is a room to have experts from our network to be involved in the process, like not as those people who draft, of course, but maybe we can provide our inputs, share our experience. Do you see possible options for our cooperation with?
Yes, Venice Commission is always cooperating with civil society, so in different countries. So it would be possible. I think let's discuss it a bit, perhaps outside of this event. We can find a solution.
Great. Thank you very much. And thank you all for your sincerity, for sharing your thoughts and ideas. And now I'm passing the floor back to Kata, and my apologies for exceeding the timeline.
For this very helpful information, for inspiring speeches, which is very important for us to continue working on these activities and recommendations in the future. And now I see the hands raised up, and I would think that just several questions we can take from the audience. So Ahat Ikarishvili, please, you can ask the question.
Hello, everyone. Can you hear me?
Yes.
Okay. So I'm Kahat Zikarishvili. I'm a member of the group of independent lawyers. I want to ask questions and raise a couple of suggestions concerning judicial cooperativism. And I want to, first of all, I'd like to mention the Georgian context. And in Georgia, 4 judges have been sanctioned by the United States and abuse of power. The opposition has demanded the creation of a special investigative commission, and the opposition had enough votes. They had 50 votes in the parliament, so they theoretically and practically they were ready. They were ready to create investigative commission. Unfortunately, the majority party, they blocked the creation of the commission because they did not, for 3 days, for 3 consecutive days, they actually did not register for the vote. So the vote was canceled for 3 consecutive days. They blocked the creation of the investigative commission. So in Georgia, the corruption and the abuse of power is quite a very actual, very, very important. These are very important topics, and also the corporativism. And my question is about whether the Council of Europe, and probably this question is also to Mr. Taras Pashu, whether the Council of Europe has any definition, any clear definition of corporatism, and whether it is preparing a document on defining corporatism in the judiciary and the causes of the corporativism in the judiciary, and forms of corporatism in the judiciary, and the remedies, how to solve the corporatism in the judiciary. I will just, I'm going to need just one, I think 30 seconds to give you my points. About the questions. The question is, how is the corporatism different from the sound judicial resistance? And when the judges, they come together, they protect themselves. This is very normal. You know, the judges, they come together, they protect themselves. It's okay. But how is it different from the bad corporatism? Then in Georgia, you know, I would say that in Georgia, based on from the Georgian experience, when the judges gather not on the value, not around the value of judicial independence, but they gather on the value of survival. They want to survive. They want to survive the new government. That's why they stand together, first of all. Second, they want to reappoint themselves. That's why they stand together. Thirdly, there's some, they have some corruption interests. Some of the judges, they have corruption interest, and they want to proceed with corruption, and they want to use judicial independence as a shield from prosecution. Third point is that the judges, they can have a deal with the political power. And this is also an expression of the corporatism. They can deal, they can have a special deal with the political power, and that's the part of the corporatism. The fourth point is that judges in Georgia, they were very vulnerable because their mandate was expiring. So from 2012, everybody lost their job, unless everybody lost their mandate gradually. So they had to be reappointed. So they were very vulnerable in Georgia, and they had to make a deal with somebody. And this was a clan that we call, the people that we call the clan, the mafia guys inside the judiciary. The fifth point is that corporativism, very dangerous in small judiciaries. Probably it's not so dangerous in big judiciaries like, several thousand judges. But in Georgia, we have 340 judges, and it's very dangerous because they can control everyone. It's very easy to control 340 people. The corporativism can also lock the borders, can lock the door to enter the judiciary. And this is what happened in Georgia. you cannot enter the judiciary unless you have served as a judicial assistant and your judge is a friend of the clan. And that's statistically proven. I mean, that's statistically proven that you cannot enter a judiciary without being a judicial assistant. The sixth point is that we have a high school of justice, which has a monopoly over judicial entrance. And a very small number of people get in the high school of justice, very small number of people, and they are controlled. I mean, the gates are very tightly controlled. The seventh point is a disciplinary system can be used to protect the favorite judges. Ninth point is that the judges who are loyal to the clan, they can be promoted in the system. The judges who are loyal to these mafia guys, they will be promoted. And the 10th point is that this mafia, which is governing the corporation, they are ready to execute political assignments on specific cases. So they have a deal with the political power. And the last point is that there is a gate. There's a big contradiction. I would say confrontation between the clan and the civil society in Georgia. Actually, we don't even talk to each other. I mean, they do not come to our events, and we don't go. I mean, we are not invited to their events. I mean, they're not inviting us to their events, basically. And there may be, of course, remedies such as deconcentration of power, such as vetting, such as lustration of the relatives inside the judicial system, and so on and so on. So finally, I would ask, my final question would be, what do you think about, in the future, what do you think about joint European guideline on corporativism in the judiciary? Thank you.
Thank you, Kaha. I think Mr. Taras, it was question to Mr. Taras, yes.
Thank you very much. How much time do I have? Because
yes, we have not much time. I think just one or two more questions, and we will finalize our meeting. Just 3-4 minutes.
Okay. Then very briefly, and I will not be able to answer everything that Mr. Kaha asked. The problem of judicial corporatism has been addressed in 2 opinions on Georgia, specifically highlighting this problem in Georgia. But judicial corporatism exists in other countries, and this is the result of improper organization of judicial councils and the procedures for taking decisions by these councils. If we are talking about the participation of judicial members in the judicial council and lay members, and this idea is fixed usually on the constitutional level, then the organization of the judicial councils and their decision-making procedures should be ensured in such a way that both parts of this membership in the judicial council should effectively participate. It cannot be accepted that at the end of the day, one group, be it judicial members or lay members, can decide by themselves any question that is within the competence of the judicial council. This was, for example, in Georgia, when judicial members could take any decision on their own without involving lay members. In fact, there were no lay members for 4 years in this country, in the judicial council. We can take an example of Bulgaria, where lay members are present, but because of the inappropriate eligibility criteria for lay members, these lay members were all 100% representatives of the prosecutor's office. So being elected under the quota of lay members, they were still representatives of the prosecutor's office. So it is the question of proper organization, of balance and participation of lay members, real lay members, and judicial members. Another question is
sorry, Taras. Just one very, very brief Georgian point. What happens if the parliament, I mean the ruling party, appoints the lay members who are loyal to the judicial mafia, which happened in Georgia right now 2 months ago? Which happened? The ruling party appointed lay members which are loyal to the judicial mafia, so that they now have a full package of High Council of Justice. Unfortunately, some opposition members also voted, but this was a big scandal here in Georgia because there is an allegation of corruption. But I'm not going to follow this point very much. But what are we going to do if there is a political deal between judicial mafia and the political ruling party? So how are we going to break that deal? That's the question.
I cannot make this assessment, and I don't know the reality and the facts. But I think it is the question of which lies within the national competence. There is no answer at this on the international how to. Well, there are the idea on the international level is that such lay members of the Judicial Council normally should be appointed or elected by qualified majority to ensure that different political forces can participate, and they will be asked to participate in such a vote. No simple majority should be enough, but qualified majority. However, there might be different circumstances, and even the ruling party can have the qualified majority. So it depends. But one of the solutions is to ensure that such important public officers are elected by the qualified majority in parliament. Second option is to ensure that such members of the Judicial Council are elected not simply by the parliament, but also are screened by the independent body. This is one of the recommendations which we were presented today. It is very important. Another option is that it depends on the domestic system, but if there is some authority which is highly trusted by the society, then these candidates should be supported, for example, preliminarily supported or screened by such authority. So there are different models. It depends on how the legal system, the domestic system is organized, and then it is for the domestic legislator to propose a specific model.
Thank you very much for the answer. Now, Eka Simakoridze also wants to ask us a question, and then Zhenya Petrosyan.
Yes, thank you, everyone. I will really try to be very brief so that I give opportunity to ask questions. Others also, I see hands raised. I just wanted to clarify with Taras, maybe you mentioned that there should be balance between lay and judge members in decision making, so that none of those groups are able to take decisions solely. But in Georgia, you have this situation where 9 judges can make decisions against one non-judge, including one non-judge member, but other 5 non-judge members are excluded, could be excluded from the decision-making process. Is it enough to have one non-judge member on board and make those decisions, just to clarify that? Also, I wanted to mention about the corporatism that we made this study little more than 1 year ago, which assesses the reforms in the Eastern European countries during judicial reform during past 30 years or so. Some of those countries are now members of the European Union, others are trying to become, but it was, for me, it was very interesting to see the similarities and the trend. All countries started from depoliticization process, which means taking out from the councils, judiciary councils, the politicians. Then it did not work. Then they started to strengthening self-governance of judges. And then they realized, almost in all countries, that even self-governance is not working, and now they are. I'm trying to be very brief, and I'm not going into details. I can share the study with whoever is interested, but then the third round of the reforms was where every country tries to put more non-judge participation, more societal participation in the decision-making processes in the judiciary. So this was very interesting and obvious trend in the countries, and maybe this should be also, I don't know if in Europe, if there exists such study for some different study or maybe academic thesis about it, but yes, it was really interesting to see the trends of the reforms. What is the road the countries are going through, to understand how corporativism prevails and how self-governance is not enough, judicial self-governance is not enough to answer this problem. And one very brief question Lovely was mentioning about political will, and I think you said that there should be a political will, efficient laws, and motivated fighters. I take this as something cumulative, because you cannot have political will on its own, right? You need some maybe incentives, some other incentives, outside incentives to generate political will. If there are no, and if I'm wrong, please correct me if your experience and insight is the same. But when, because in Georgia, they talk about political will so much that even we sometimes consider that it does not make any sense to fight for the reforms until, for example, certain government is in place, in power. So political will, if you ask me, political will is something that there is one if there is a demand for some reforms and etc. from society. Thank you. Thank you very much.
So there was two questions. One was to Taras, and let's begin. Taras, please, and after Lovely will answer.
Yes, this is about the procedure of taking decision by the Judicial Council. As I briefly mentioned earlier, the idea of lay members, which has been developed recently, more or less recently, in response to the problem, exactly in the response to the problem of judicial corporatism, in order to ensure that judicial councils are more accountable to the society. So that's where the lay members would be able to contribute. But they should not be just nominal. They should effectively participate in the decision-making process. So the idea was to think about ensuring the double majority principle, let's put it in this way, so the decision is taken on one side if the majority is taken by the judicial members, but also if it is sufficiently supported by the lay members. So not simply counting the overall number of members and then finding the majority or seeking for the qualified majority, but ensuring that this majority is also consisting of the votes coming from the lay members. This can be clearly stipulated in the specific laws regulating the procedure for taking decisions by the judicial councils. I'm sorry, I cannot elaborate more because we don't have time.
Yes,
That's a very important issue,
yes,
which the Venice Commission discussed recently in several opinions.
I apologize for it. Is so interesting to listen to you that we have some question, but the last will be Zhenya, and I will ask the audience not to ask more questions because we have to finalize our meeting. And Lovely, please.
Thank you for the question. And first of all, I'm ready to continue with you, but now very shortly. First of all, if I talk about political will, when we talk about sincere political will, forget all the dirty politics. We talk about the real political will. Because can you imagine that you have really motivated fighters, judges, prosecutors, investigators, and there are no budget, there are no resources, there are no law? Is it possible to fight? Yes, in some way. And I would like to wish you power to continue if you don't feel the political will. But if we want results, then we need the political will. And all the vetting process then can take place only because we have the political will. But at the same time, the political will, that means also that this political will accept rule of law. They accept independent judiciary, and that's the value. So, but very shortly from my side, I don't know, was it the question, but you can write me and I can answer in the future longer.
Thank you very much, Lovely. And the last question, Zhenya Petrosyan, she wants to ask a question. Please, Zhenya.
Thank you. The topic is really interesting from the side of Armenian legal community as well. Actually, we used to have this problem of a structural problem of corporativism, both in the Judicial Council and the Disciplinary Commission for years. And I'm specifically interested not in the level of Judicial Council, but the Disciplinary Commission. Usually it is called Disciplinary Commission, Ethical Commission, or Board, which is instituting disciplinary proceedings against a judge before the case goes to the Judicial Council. So first of all, the motion should be examined by the Disciplinary Commission. And if it institutes proceedings, only then the case goes to Judicial Council for deciding whether there was a disciplinary violation in the actions of the judge or not. So I'm interested in the approach concerning this specific body, whether it is the same approach that there should be a balanced composition, for example, 50% lay members and judge members, or there is, for example, different state representatives in Armenia are of the opinion that in this body there should be more judge members, so there shouldn't be equal representation of lay members and judge members. And the second question concerns the procedure of adopting instituting disciplinary proceeding against a judge. For example, in Moldova, I know there was a draft law according to which one vote for instituting a disciplinary proceeding was enough for adopting this decision, because the disciplinary board was composed of 3 members, 2 judges and 1 lay member, and they kind of introduced this amendment for giving more weight to the vote of the lay member, so that the lay member can effectively participate in the decision-making process. Do you think that this procedures can also be used as a good practice in other countries? Thank you.
Thank you, Zhenya. To whom it was addressed this question? Again, to Taras, yes, I think.
I think yes.
Thank you very much. With pleasure. Very briefly,
Yes,
I would just say that these recommendations concerning the participation of judicial members, we have discussed about it quite a lot even today. They concern rather the judicial councils, and the idea is just to ensure that professional liability is being examined by the professionals. So this participation, this quota of judicial participation is important. The question is about that your particular structure is a little bit different because it is composed of several bodies, which is also possible, which exists in other countries, and this is not a problem. The question is about who is taking the final decision and who is empowered to assess all the relevant facts and make legal assessment of these facts. Normally, I would assume that it still remains with the Judicial Council, even if before you have some preliminary assessment. You may have preliminary assessment in different stages of legal proceedings, but it doesn't mean that at each stage there should be certain representative, because even if you take the criminal investigation, there is an investigator who is first making some legal assessment of facts, who is collecting. But well, so basically the idea of participation of judges should remain with the Judicial Council. However, it does not prevent the other bodies of trying to ensure this principle of professional assessment on the preliminary stages. So it can be only welcome, assuming that this procedure is not aggravated and is not complicated in total. And
thank you, but yes, thank you for your answer. But in our case, actually, the disciplinary body, the commission, can just block the case. So the case can never reach the Judicial Council because the proceeding is not instituted in the disciplinary commission level. So actually, for example, more than 90% of motions going to the commission are blocked by judge members of the commission, and they never go to the Judicial Council. So you can never get a chance to get the case examined in the Judicial Council, because at this level, it is just not accepted.
I see. Then, well, then it is not. It is probably not a sufficient guarantee that everything is focused on the Judicial Council if it remains not really functional in this particular context. And your second question, please remind me because I don't remember.
The procedure that actually we have not the majority of votes for deciding institute disciplinary proceeding against a judge or not, but even one vote or the minority votes equal to the votes to the number of lay members is enough for having this decision. For example, in case of Moldova, I remember there was a Venice Commission opinion on that, saying that it is normal to have this kind of, maybe it is not a standard procedure, because usually we have majority votes for adopting a decision. In this case, it was minority vote enough for having the case instituted. I think, for example, this could be a solution.
Well, instituting disciplinary proceedings is a different issue. It might be even difficult to identify the moment when disciplinary proceeding actually starts, because there might be some preliminary checks, preliminary inquiries, some questions, some interviews with judge. It is already something which is going on, and judge should understand that. But the problem is that there are some guarantees that should be ensured from the moment the disciplinary proceedings have been instituted formally. It is not that crucial, I would say. So there are no some such strict requirements how to institute what is the majority. In some countries, even one member of the Judicial Council can start examining after receiving a complaint. So it's not a problem. I would say that there are no, it depends, it very much depends on the particular system and model. So it would be not easy for me to answer right now on such a limited information that you have provided. I'm sorry, it depends. But generally, there is no such a strict rule on how many votes you have to receive to start the disciplinary proceedings.
So thank you, Tara, so much. I think that we finalize our meeting. We have passed our time, and I want to thank our speakers, Taras, Tilman, Lovely, Nona, and especially Halia for her effort in this very significant process. And I think that we will continue to work on this recommendation, and also will envisage these advices which we have from the speakers. And also I want to thank all other participants and special guests who are attending our discussion. I think it's not the end of the process, it is beginning of the process, and thank you so much. If Halia wants to add something, if not, thank you. And okay, Halia.
I just want to say that I'm sorry that our time as always is limited, because I know that we could move discussing these issues. Thank you very much to all of you from the bottom of my heart, to our speakers for sharing their ideas, opinions, to Georgian colleagues for organizing this event, to all experts who were with us today. Sorry, we didn't have enough time for your questions, but I believe that it's not our last event on this topic. We'll keep working on promoting good solutions for democracies. So let's stay in touch.
Thank you very much to all. Thank you and goodbye.